To begin, the issue of the question is to determine whether the statement that the creator of intellectual property is necessarily the owner of the property and whether that this statement is fair to the various forms of intellectual property. Intellectual property rights are important as the creator creates his work, and depending on the type of his work, he may register a form of intellectual property for protection where he would have the sole exclusive rights to the work. Intellectual property rights is an important role in the development of society as it provides incentive and encouragement to the creator of the creation and encourages healthy competition amongst creators, which leads to further developments. There are various forms of intellectual property, such as copyrights, patents, trade secrets, industrial designs, trademarks, and geographical indications. A copyright can be defined as the exclusive right granted by law to reproduce and to distribute or disseminate it to the public in any manner or by any means, and to authorize others to use the work in specific ways. The relevant provisions that explains copyright is firstly Section 3 of the Copyright Act 1987, which defines fixation where it is the embodiment of sounds, images, or both. This provision explains material form in relation to a work includes any form from which the work can be reproduced. Section 7 sub 1 offers protection to works such as literary music, musical artistic works, films, sound recordings, and broadcasts. An illustration of a copyright infringement case would be Goodyear Tire and Rubber Company and Another versus Silverstone Tire and Rubber Co. Sdn Bhd, which dealt with the question on whether the defendant had copied the tread sign of the plaintiff's tires, thereby infringing the plaintiff's copyright drawings of their tires. The High Court refused to grant an injunction. The court held that what the plaintiffs were basically seeking to protect was the idea of the function of the tire, which, being an idea, the law of copyright did not protect. In Hexagon Tower Sdn Bhd and Polydemic Holdings Sdn Bhd and 3 others, Section 10 sub 3 was applied where it was held that it is imperative that the registration of a design is done in Malaysia. On determining whether the principle by the question is fair, the relevant provisions would be firstly Section 26 sub 1, which provides that the copyright shall initially rest in the author. In other words, the ownership of copyright belongs to the creator upon in a fixation tangible medium. However, the copyright holder may sign an agreement that the work was made for hire, therefore the hiring company or individual owns the copyright. This will be provided in Section 26 sub 2, where it stipulates that if a work has been commissioned by a person who is the author's employer under a contract of service or apprenticeship, or if the work is made in the course of the author's employment, the copyright is deemed to be transferred to the person who commissioned the work or the author's employer. And this presumption prevails unless there is any agreement between the parties excluding or limiting such transfer. For example, the creator's work can be transferred to a third party and the creator would no longer reproduce, present, or publish the work elsewhere. However, a publisher may permit the creator or author certain rights with the work, but still the author would generally retain the rights to be credited as the author. Another presumption of ownership that exists is that according to Section 26 sub 4 subsection A, the name on a work purporting to be the name of its author shall be considered as such unless the contrary is proved. Section 27 sub 2 stipulated that the copyright is transferable by assignment, testamentary disposition, or by operation of law as movable property. Further, in the Berne Convention is an international agreement governing copyright, and it would apply in Malaysia as it is a member of the Berne Union in 1990. Article 6b sub 1 of the Berne Convention provides moral rights for the author regarding copyright. It states that independently of the author's economic rights and even after the transfer of the said rights, authors shall have the right to claim authorship of the work and to object any distortion, mutilation, or other modification of or other derogatory action in relation to the said work, which would be prejudicial to its honor or reputation. It seems that the law favors the rights of owners more than the rights of authors, and copyright strives to maintain a balance between their rights. The rationale underlying the balance can be viewed from several perspectives, one basing on the natural rights of the author to the property in the work created. Secondly, the based on the notion of fairness that the author and entrepreneurs should be rewarded for the effort expended in the creation of the work. Thirdly, based on the notion of incentive that to encourage creative activities and simultaneously allowing the public to obtain access to work and knowledge, authors and those who exploit creative works must be given sufficient incentive to create and exploit such works. Therefore, it can be deduced that from the affirmation provisions, the ownership of the copyright work would be owned by the owner initially, and it is up to his own volition whether to transfer his work by way of Section 27 sub 2. Furthermore, Section 13 sub F explains that the source and the name of the author appears on the work used, thus giving public recognition that the author is the creator of the work. Further supported by Section 26 sub 4 subsection A, which provides that the name of the work is to be the name on the work is to be the name of the authors. Thus, even if the author transfers the copyright of his work, he is still given recognition as the creator. Further, as Article 6b sub 1 provides, moral rights to the author to have a claim on the authorship of the work and to object any alterations to his work if it may be detrimental to his status. However, this is arguably a limited right, as it would only allow the creator to claim on the authorship, not the ownership, and this provision is only invocable if an alteration is made which may affect the author's reputation. But with all things said, the creator is not necessarily the owner if he decides to transfer the copyright to another party or is an employee hired to create the work, and it is fair to a certain extent, as even if he is not the owner, recognition as the creator is still given. The next form of intellectual property would be patents, where a patent is an exclusive right granted for an invention, which is a product or a process that provides a new way of doing something, or offers a new technical solution to a problem. Section 3 of the Patents Act 1983 defines patented inventions as an invention for which a patent is granted, and patented process and a patented product means a product which is a patented invention, or in relation to a patented process, a product obtained directly by means of the process or to which the process has been applied. In Malaysia, the Patent Cooperation Treaty was implemented in 2006 as the patent filing system. The governing statutes for patents would be laid out in the Patents Act 1983, where for a work to be eligible for a patent, Section 11 states that the invention is patentable if it is new, involves an inventive step, and is industrially applicable. Section 12 sub 1 defines the meaning of an invention, which is an invention of an inventor which permits, in practice, the solution to a specific problem in the field of technology. Section 17 states that the Act would apply to utility innovation, which means any innovation which creates a new product or improvement to a product or process. Generally, the inventor is the first owner of an invention. However, ownership of the rights to a patent may pass from the inventor to the employers. Section 36 sub 1 provides that the owner of the patent shall have exclusive rights. This highlights that the creator can completely be the owner of the creation. However, if he is under an employment contract, the creation is deemed to be owned by the employer, but still he is entitled to a remuneration if the invention unexpectedly exceeds the economic value as provided under Section 20 sub 1. Therefore, for patents, the creator is not necessarily the owner, and even if under an employment contract, the creator would still have a right to be entitled to a remuneration explained. Thus, it can be concluded that the owner is not necessarily the owner, and this principle would be fair in regards to patents due to the exclusive rights and remuneration rights provided under the Patents Act 1983. Industrial designs are defined under Section 3 of the Industrial Designs Act 1996, where it states that an industrial design means features of shape, configuration, pattern, or ornament applied to an article by any industrial process or means, being features which, in the finished article, appeal to and are judged by the eye. Under Section 10 sub 1, it stipulates the author of a design would be treated as the original owner, and under Section 10 sub 2, when a design is created for money and the person commissioning the design will be treated as the original owner. The right of the owner would be as stated by Section 10 sub 1, where he would be the owner, and if it was done for hire, it would be owned by the hirer. However, there seems to be no further elaborations on the rights of the owner and author. Thus, according to the Industrial Designs Act 1996, it is true that the creator is not necessarily the owner, and on whether this principle is fair, it can be concluded that it is fair. The reason for this conclusion is that the creator becomes the owner if it was not done under a contract, and it would be reasonable if there is a contract between the creator and the owner, thus giving ownership to the employer. The next form of intellectual property would be trade secrets. A trade secret is where some sort of information that has value, but it is not generally known. It includes a formula, pattern, compilation, program, device, method, technique, or process that derives economic value from not being readily ascertainable and is the subject of efforts that are reasonable under circumstances to remain in secrecy. In short, one might classify a trade secret as anything advantageous in business activity that is not generally known to members of the trade. Article 39.2 of the Trade-Related Aspects of Intellectual Property Agreement, in short TRIPS, defines trade secrets as information that is secrets, which has commercial value because of its secrets and has been subjected to reasonable steps to keep it secrets. There is no statutory definition of trade secret in Malaysia. The Malaysian courts have relied on the definition of English cases and applied common law definition in dealing with cases involving trade secrets and confidential information disputes. A case illustrating trade secrets would be Electrocat Australia Private Limited and two others versus Merjati RCS and Berhad and others, where Justice Kamalanathan Ratnam explained trade secrets as information which any reasonable employee would recognize as secret to his employer's business, and that an action for breach of confidence will lie where there is a breach of an obligation of confidence. Here the defendants used information from the plaintiffs without their consent and created a product. The court granted an injunction and rewarded damages to the plaintiffs. This illustrated that information can be property. As Malaysia does not have legislation that criminalizes theft or trade secrets, and as a member of the Trans-Pacific Partnership Agreement, TPPA in short, under Article 18.78 provides that the criminal procedures and penalties for a breach of its provisions. Thus, Malaysia being a member of the TPPA, it must enact specific laws to deal with unlawful disclosure of trade secrets and provide procedures and penalties if breached. For example, in the US in 2015, the Defense of the Trade Secrets Act was enacted, making a civil action for misappropriation of trade secret. Thus, both civil and criminal law can be commenced against the wrongdoer. Therefore, Malaysia needs to have a statutory definition of trade secrets for the purpose of proving ownership and economic value of the trade secrets. It can be seen that due to non-existence of statutes in Malaysia to govern trade secrets, thus ownership cannot be established. So when trade secrets are misappropriated, the creator or owner would not be able to enforce their rights. Therefore, the principle of the question that it is unfair would be unfair in this particular area. What can be done about this is that Malaysia should make changes to its legislation as Section 378 of the Penal Code regarding theft does not recognize intangible assets as trade secrets are intangible assets. The last intellectual property would be trademarks. Where a trademark is defined in substance, a sign. It can be denominations, letters, numerals, combination of colors, or any combinations of these elements. A trademark is defined by its function. The sign has to be distinctive. Originally, the trademark law was designed to fulfill the public policy objective of consumer protection. It prevents the public from being misled as to the origin of quality of products. A trademark is defined in legal terms as a type of industrial property. Trademark protection grants the owner the exclusive right to use the signs to identify the goods or services produced or another party to use them in return of payment. Section 3 sub 1 of the Trademarks Act 2019 defines trademarks as any sign capable of being represented graphically, which is capable of distinguishing goods or services of one undertaking from those of other undertakings. Under Section 16 of the Trademarks Act 2019, it states a registered trademark is property right obtained by the registration of trademark, and the registered proprietor of the trademark has rights and remedies provided under this Act. Further, under Section 17 sub 1 sub A and sub B, it stipulates that any person who claims to be the bona fide proprietor of a trademark may apply for the registration of the trademark if the person is using or intends to use the trademark, or the person has authorized or intends to authorize another person to use the trademark. Under Section 48 sub 1 sub A and sub B of the Trademarks Act 2019, it stipulates that the registered proprietor of trademark has the exclusive rights to use the trademark and authorize other persons to use the trademark. And lastly, Section 52 sub A provides that in all legal proceedings relating to a registered trademark, the register shall be prima facie evidence. Under the law, a trademark can be registered and protected by virtue of Section 16 and Section 52 sub A. However, unregistered trademarks are protected by common law rights in form of the tort of passing off, as Malaysia acknowledges the right of the first user for trademarks. This was illustrated in the High Court case of Syarikat Zaman Haji Tamin Sembilan Berhad and another, and Yong Zefun and another. It decided that the first user of a mark in Malaysia would prevail over the subsequent user, or otherwise it will result in an anomaly in the law, in the sense that the first and original user of a mark is defeated by a subsequent user. Therefore, Section 16 provides that any person who wishes to protect a trademark may register it, and Section 48 provides the rights of the owner. Thus, if the creator of a mark registers it, it will be prima facie evidence according to Section 52 sub A, and he would be the owner of the mark. However, the first user system may not be fair to the creator if the mark is unregistered, as he may not have used it, but another party uses it. The party would then have ownership of it. If the creator wishes to protect the mark, he would have to register it to have ownership of it. Thus, it is true that the creator is not necessarily the owner of, and the rights of the creator to an unregistered mark is unfair due to the fact another party may use it and then be the owner of it. To determine whether the aforementioned statement by the question is fair applying to intellectual property as a whole, firstly, an intellectual property created by an individual or individuals come from their talent and innovativeness. Thus, it is tied to their personhood. Therefore, there is a concept of originality that if the origin of the song is of someone's, then it is original to him. Therefore, I will argue that the creator will still somewhat be the owner of the creation, as recognition and credit is given, such as putting his name on the cover of a book, although not being the legal owner. But as the work's source is of the creator's expression, he in a sense would be the owner to a certain extent. A reason that owners of intellectual property work transfer the rights to others could be because of monetary gain in the world of capitalism, which would lead to the originality of the work to be altered, thus destroying personhood. Therefore, it can be deduced that the creator would not be the so-called owner. Thus, I would say in this aspect, alteration by the legal owner of the creator's work would defeat the purpose of originality. Thus, the fairness of whether the creator is not necessarily the owner is unfair to a certain extent, but in the moral context. In conclusion, legally, a creator is the owner of the work, and sometimes they are not necessarily the owners if the work was done on an employment basis or been transferred from the creator to another party. Thus, this would be a fair principle under the provisions provided. However, when it comes to morality, it is arguable as the creator would have a personal connection with his work, and when his work is owned by others and he loses his rights over it, it severs the connection, thus he would not possess any rights to control the work, thus defeating its original purpose. Lastly, although moral rights can be enforced through Article 6 of the Berne Convention, it is however still limited as explained because it is subjected to circumstances. Therefore, the principle whether the owner is not necessarily the owner is statutorily fair, as stipulated by statutes. The owner of the work initially rests in the creator, and if done under an employment contract, the employer owns it, and if the creator decides to transfer the work, the party would be the owner.